On the 29th of July, an unsigned costs order sat on a High Court file, waiting for Prince Harry's Crusade to meet its bill. 2 days had been set aside at the Rolls Building for something the case had avoided for years. A plain reckoning of who pays and how much, now that the fight over phone hacking has moved from principle into arithmetic. For 4 years, Harry's case against Associated Newspapers has been framed publicly as accountability, as a stand against an industry that never faced consequences for how it gathered its stories. That framing survived headlines, survived a partial strikeout of the claim, survived even the moment a judge ruled that most of what Harry alleged could not proceed to trial. What that framing has never had to survive, until this week, is a specific number with his name next to it. Reportedly, that changes now. The 29th and 30th of July were set aside for what the court calls consequential orders, the unglamorous machinery that follows a ruling. Who owes what, on what schedule, and under whose signature. Consequential orders hearings rarely make headlines on their own. They are the paperwork after the drama, the part journalists usually skip. But sit with that detail for a second, because it is the whole story here. A campaign that has spent 4 years describing itself in the language of principle was about to be described, in a courtroom, in the language of debt. Nobody sends a spokesperson to fight a cost schedule. You send lawyers, and lawyers negotiate figures, not feelings. To understand why an unsigned costs order matters this much, you need both sides of this fight, because they wanted very different things from the same piece of paper. Harry's side, the keeper of the accountability claim, needs the public to keep believing that Lawrence and others versus Associated Newspapers was never about money. It was framed from the start as a stand alongside Baroness Doreen Lawrence and other claimants, including Elton John and his husband David Furnish. Together, they alleged years of unlawful information gathering by a major British newspaper group. The claim's entire moral architecture depends on that reading. Individuals who could have quietly moved on, instead, chose to fight, at real personal cost, for a principle bigger than themselves. Harry, specific to his own public messaging, has repeated some version of that idea for years. He is not doing this for himself, he has said, in effect, more than once. He is doing this for a press he says has hunted his family since before he could read a newspaper himself. Associated Newspapers, the challenger holding the current receipt, needs a very different story to hold. In December of last year, Mr. Justice Nicklin struck out the bulk of the claim. He ruled it had been brought too late, and that key allegations lacked sufficient evidence to proceed to trial. That ruling did more than end most of the case. It handed Associated Newspapers something concrete, a legal basis to ask the court formally for its money back. Not symbolically, actually specifically, with a schedule of costs, the kind of itemized document that lists every hour of legal work, every filing, every hearing, and prices it down to the pound. The publisher's lawyers were not interested in the moral architecture of the claim. They were interested in what the ruling entitled them to recover, and from whom, exactly. 2 sides, 2 documents, 1 hearing. The keeper wanted the case remembered as a crusade. The challenger wanted it remembered as a loss with a price tag attached. The 29th of July was where those 2 documents were finally going to occupy the same room, in front of the same judge, on the same file. The night before the hearing, according to 2 people close to the claimant's side, Harry's legal team gathered in a rented office 2 streets from the Royal Courts of Justice. They went through the costs schedule, line by line. The room was small, the kind law firms use for overflow meetings, with a single window looking onto a fire escape, and a desk lamp that buzzed faintly whenever the heating clicked on. Harry was not required to attend in person that evening, and reportedly did not. But he was on a call for the last 20 minutes, his voice flat over speakerphone, as his solicitor read out the total the other side intended to claim. There was a pause on the line, long enough that someone in the room checked the call had not dropped. Then Harry asked one question, according to a person in the room, whether the figure being discussed was his alone or the group's. The answer, his solicitor said carefully, was complicated. That single word, complicated, is doing a great deal of work in this story, and it is worth sitting with, because complicated is exactly what a moral crusade is not supposed to be. Crusades are simple by design. Cost schedules are not. The next morning, day one of the hearing opened, not with testimony but with submissions. Lawyers were on their feet arguing about apportionment, about what percentage of costs each claimant should bear, about whether costs could be assessed jointly or needed to be split individually. Associated Newspapers Counsel argued for joint and several liability among the claimants who lost. In plain terms, that legal mechanism means any one of them could be pursued for the full amount if others could not or would not pay their share. Harry's counsel pushed back, arguing for individual assessment, a structure that would tie each claimant's exposure to their own specific conduct in the litigation, rather than the group's collective failure. What matters here is not the legal technicality. What matters is what it reveals in action. A campaign that had spent years insisting this was never about money spent its first day at the costs hearing, arguing about exactly how the money should be divided among friends. It went on, specifically, and at length. The keeper's claim that this was principle rather than finance was not being explained to the viewer by a narrator standing outside the story. It was being contradicted in real time by the keeper's own lawyers standing in a courtroom, negotiating who owed what to whom. By early afternoon, Associated Newspapers team had produced their full schedule of costs, the itemized document their in-house solicitors and an external costs draftsman had spent weeks preparing. According to a person familiar with the drafting process, the costs draftsman working the file had flagged one line for special attention. It is a specialist role most viewers have never heard of. The flagged line covered 11 months of disclosure work, tied specifically to material Harry's side had demanded during the case. Those requests ultimately produced nothing the court found probative. The senior partner reviewing the draft reportedly circled that line twice and wrote a single word in the margin: emphasize. It is a small, procedural, almost bureaucratic detail. It is also, genuinely, one of the more damning receipts in this entire story, because it does not accuse Harry of anything he said publicly. It prices what he privately asked for. By the end of day one, the unsigned cost order remained exactly that, unsigned, its final figure still contested by both sides. But the shape of it had changed. It was no longer an abstract number attached to a case people already had opinions about either way. It was, specific line by specific line, becoming an itemized account of choices Harry's legal team had made during 4 years of litigation, and Associated Newspapers wanted every one of them counted, priced, and paid. Day two began with a different kind of pressure, and it did not come from Associated Newspapers at all. It came from inside the group of claimants Harry had stood alongside since the beginning. Reportedly, in the days before the hearing, at least one other claimant's legal team had raised a private concern with the joint claimant's solicitors. If the court imposed joint and several liability, and any claimant's finances proved unable to absorb their share, the shortfall could fall on whoever remained financially exposed. Harry had the most sustained public profile in the group, and among the deepest pockets, in a group that included actors and a long-time campaigner. In blunt words attributed to one person on the claimant's side, he was the name everyone quietly assumed could cover the gap if it came to that. Nobody said that out loud in open court. According to someone familiar with the claimant's internal discussions, it was said on a conference call 2 days before the hearing began. It landed badly enough that a second call had to be scheduled, just to smooth the feeling over. Into that tension stepped a detail the tabloids had already been circling for weeks. Elton John and David Furnish, fellow claimants and longtime friends of Harry's, had privately offered to help cover legal costs if the group's exposure grew larger than expected. Whether that offer was ever formalized in writing is not something this video can confirm, and it should be said plainly that it remains unconfirmed. What can be shown is the effect the rumor had inside the case itself. It reframed, instantly and uncomfortably, what standing together as claimants actually meant in practice. A crusade that had presented itself as a united front of principle now had a quieter, parallel story running underneath it. A story about who could actually afford to lose. Genuinely, sit with that detail, because it is the midpoint turn of this entire story. The public narrative was never designed to survive the question of individual solvency. It was designed to survive as a chorus, a group of people speaking as one about press accountability and the cost of standing up to it. The costs hearing did not ask the chorus to sing together. It asked each voice, one at a time, what they were personally good for if the bill came due. Inside Associated Newspapers' offices, the mood was reportedly closer to procedural satisfaction than triumph. One in-house lawyer, speaking to a colleague after the morning session, put it plainly, according to someone who overheard the exchange near the lift. This was never designed to be a moral victory for the paper. It was designed to be a costs victory. Full stop. The distinction matters more than it sounds. Associated Newspapers did not need the public to believe the newspaper had been vindicated on every allegation. It needed the court to believe the claimants had lost, and to price that loss precisely, in pounds, on a schedule. By lunchtime on day 2, their solicitors had submitted a request. They wanted Mr. Justice Nicklin to order an interim payment on account of costs. That mechanism would require the claimants to pay a substantial portion of the disputed total immediately, before the final figure was even settled. It applies simply because the judge is satisfied the newspaper will ultimately recover at least that much, regardless of how the apportionment argument ends. An interim payment on account is, mechanically, one of the less dramatic corners of English civil procedure. It exists so that a winning party is not left waiting years for money it is clearly owed, while the final accounting drags on through a costs office. But watch what it actually does here. It converts an abstract, disputed total into an immediate, real transaction, due on a court-ordered date, regardless of whether the individual apportionment fight has been resolved between the claimants themselves. The unsigned cost order was no longer just unsigned. It was about to become due. By mid-afternoon, Harry's counsel was arguing, specifically, that any interim payment should be modest and proportionate. It should be clearly attributed only to conduct the court had found unreasonable, not to the litigation as a whole. It was, in effect, an argument that the Crusade should be allowed to keep its meaning even as its price was being calculated line by line in the same room. Mr. Justice Nicklin, according to 2 people present in court that afternoon, listened without visible reaction and said he would rule the following morning on both apportionment and the interim figure. The room emptied without a number attached to anything. The unsigned order stayed exactly where it had been for 2 days now, on the file, waiting for a signature nobody in that building could yet provide. The ruling came the next morning, brief and procedural in tone, the way the most consequential legal decisions often are delivered. Mr. Justice Nicklin ordered joint and several liability among the losing claimants for the bulk of the costs. Individual assessment was reserved only for a narrow category of conduct, specific to each person named in the claim. He then ordered an interim payment on account, due within 28 days. The figure would come from the court's own costs office, using the schedule Associated Newspapers had submitted, once a costs judge had reviewed it for reasonableness. For the first time since the 29th of July, the unsigned costs order had an actual mechanism attached to it, and a deadline stamped beside it. What happens next to that piece of paper is genuinely more mechanical than most viewers assume. The detail is worth knowing, because it explains why nobody could simply write a check that afternoon and end the story. The court's costs office does not process a figure this large on a judge's word alone. The schedule Associated Newspapers submitted first goes to a costs judge for what is called a detailed assessment. It is a line-by-line review that can strike out or reduce individual entries the paying side disputes as unreasonable or excessive. Only once that review is complete does the file move to the associate, who prepares the formal order for sealing. That is the actual signature this story has been circling since its opening line. 2 people who have worked cost files at that level of the court describe the same 3-step chain: the judge's ruling, the costs judge's assessment, the associate's seal. Skip a step, and the order stays exactly what it started as: unsigned. That is precisely where it sat for 2 more weeks after Mr. Justice Nicklin's ruling. The costs judge worked through Associated Newspapers' itemized schedule line by line, including the flagged entry about 11 months of disclosure work, the one already circled once in a solicitor's office. Here is the specific price, and it deserves to be named plainly rather than gestured at from a safe distance. Harry's accountability campaign loses control of the case's final public document. For years, the public record of this litigation was whatever Harry's own statements said it was: a fight worth having, a principle worth whatever it cost. After the 29th and 30th of July, the case's most concrete public document is no longer a statement issued by a spokesperson. It is a costs order, drafted by a court office, priced by a costs judge, and enforceable regardless of how anyone chooses to frame it afterward. The keeper does not get to write that document's meaning anymore. The court does. Reportedly, Harry's reaction that evening was quiet rather than combative. A person close to him described him reading the ruling summary twice, in a room with the curtains still open onto an early evening sky. Then he asked his solicitor a version of the same question from the night before the hearing began. How much of this is mine, specifically, he wanted to know, and how much belongs to everyone else? This time, the answer had numbers attached to it, even if the final figure would take the costs office several more weeks to fix precisely and in writing. According to that same person, Harry did not raise his voice. He asked instead whether a statement should go out reaffirming the principle behind the case, the way statements always had before. His team advised against it, at least for the moment. Their reasoning was simple. Any statement issued the same week as an interim payment order would read, to most audiences, as spin rather than conviction. The Crusade's most reliable tool, its own public voice, had been temporarily taken off the table by its own timing. Inside Associated Newspapers, the response was reportedly restrained, almost deliberately so. No triumphant statement, no quote naming Harry directly by name, just a short line, released through solicitors, confirming that the court had ordered payment on account, and that the publisher would provide a further update once the costs office completed its full assessment. It is a strange kind of victory lap, one that says almost nothing out loud, and that restraint is itself a receipt worth noticing. The newspaper did not need to say more, because the unsigned order, now finally in motion, was saying it for them anyway. What did Harry actually lose, beyond a sum of money whose exact figure is still being finalized behind closed doors? He lost the ability to let the case's meaning be decided entirely on his own terms, by his own statements, on his own timeline. For 4 years, the story was a fight against a press that had never been held to account for how it treated his family. As of the 30th of July, the story also includes a costs order with his name attached to a shared liability he did not fully control the shape of. It also includes a rumor about a friend's checkbook, one that no one on his side has confirmed or denied to this day. Genuinely, that is the price. Not humiliation, exactly. Not a defeat of the underlying argument about press conduct, which many observers still find credible on its own terms. Just the loss of exclusive authorship over what the case means in public from here forward. It would be unfair and inaccurate to read this purely as a personal collapse, so let's hold that thought for a moment. The strongest fair reading available is considerably less dramatic than the headlines that will circulate this week. Costs orders following a partially unsuccessful claim are standard civil procedure, not a personal verdict on Harry's character or his motives for bringing the case in the first place. Joint and several liability is a common mechanism in group litigation, specifically because courts want to avoid one solvent claimant escaping, while others cannot pay their share. It is not, on its own, evidence of individual wrongdoing by anyone named on the file. The interim payment mechanism exists in nearly every substantial costs dispute in English law, regardless of who the claimant happens to be or how famous their name is. None of that is unique to Harry, and none of it, by itself, proves the underlying case was brought in bad faith. That fair reading narrows the story considerably. It does not erase it. Even if the mechanism is entirely ordinary, the specific facts sitting inside it are not. There is the itemized line about 11 months of unproductive disclosure work. There is the internal claimant tension over who could quietly cover a shortfall. There is the rumor of a friend's offer to help settle a bill nobody wanted to discuss on the record, and the quiet evening with the curtains left open, and a question about whose number this actually was. Standard procedure explains why a costs hearing happened at all. It does not explain why this particular costs hearing produced this particular set of private moments behind it. The counter-read tells you the mechanism is not personal. The details tell you the consequences, for one specific man genuinely were. So, where does that leave the unsigned costs order now that it finally has a mechanism and a deadline attached to it? It leaves it exactly where this story began, except now everyone can see what was always going to fill in that blank line eventually. For 4 years, the public was offered a single clean read of this case. A prince who had been failed by the press, choosing to fight rather than walk quietly away, at whatever cost that fight required. That framing was never technically false. Harry has, by every visible measure, spent real money and real years on this claim, alongside people who had their own separate reasons for joining him along the way. But a moral crusade and a costs order are not the same document, and this week, for the first time, the second one became more concrete than the first ever was. The unsigned costs order did not erase the principle behind the case. It simply refused to let the principle remain the only thing anyone had to account for. What matters here, more than any single figure the costs office eventually settles on in the coming weeks, is the shift in who controls how the story ends. A campaign built for 4 years on Harry's own telling now has an ending partly written by a court office, a costs judge, and a 28-day payment deadline that does not care how the case gets framed in a press statement. That is the actual reversal at the centre of this story. Not that Harry lost some abstract battle of public opinion he was never fully in control of anyway. He lost the exclusive right to narrate what losing this particular fight actually costs him. And that is where the anchor comes back, one final time, with more weight than it carried at the start. The unsigned costs order that sat on a Rolls building file on the 29th of July is not unsigned anymore. It has a mechanism, it has a deadline, and soon it will have a specific figure that Harry's name will sit beside, whether his team issues a statement about it or not. A bill with no name on it, at the start of this story, now has one. Specific, unsentimental, filed. What the case proved or failed to prove about press conduct in Britain may still matter for years to come. Genuinely, regardless of how this particular week ended. What the costs hearing proved is smaller, and in some ways sharper. Even a crusade framed entirely around principle eventually meets an institution that only speaks in numbers. That institution does not soften its language for anyone, prince or otherwise, friend's checkbook or none. The blank line got filled in. That is the whole story, and it is worth remembering the next time anyone tells you a fight like this one was only ever about doing the right thing, and never about what doing it would eventually cost. If you have been following this case since the original ruling in December, you already know how often the public story and the court's actual paperwork drift apart from each other. This is one of those rare weeks where they finally lined back up on the same page. Tell us in the comments whether you think the interim payment changes how this case should be remembered 5 years from now, or whether the principle behind it still stands entirely on its own regardless of who ends up paying the final bill. We will be tracking the costs office's final figure once it is formally released, and if the number lands anywhere close to what Associated Newspapers originally requested in their schedule, that follow-up genuinely deserves its own video. Subscribe if you want to see exactly how much that unsigned order was actually worth once somebody finally, specifically signed it.